John Hendy, KC. I'm a member of the House of Lords. A number of councils are considering their position in relation to the Strikes Minimum Service Level Act and the regulations which have been passed and some are yet to be passed in relation to it. A number of councils don't want to be in a position where they issue work notices, and they've taken the decision not to do so. Some of them have just done it because they disagree fundamentally with the Act's interference with the right to strike. Others have done it on the basis that serving work notices in a strike situation will only exacerbate and irritate industrial relations, which will not be good for the council in the future. But there is one other reason which councils might want to take into account. That reason is that the Strikes Minimum Service Level Act appears to be in breach of the United Kingdom's international legal obligations. And the way that comes about is this, that the International Labour Organization has a number of fundamental labour conventions, and these conventions are binding on the entire world. Amongst them are Convention 87, which protects the right to organise and the right to strike, and Convention 98, which protects the right to bargain collectively. And the ILO has decided in a whole number of decisions of its constituent bodies, the Committee of Experts on the Application of Conventions and Recommendations, and the Committee on Freedom of Association and so on, how these conventions apply to the situation on the ground in various countries. Now, the government has always argued that the Strikes Minimum Service Level Act is in compliance with the UK's obligations under those ILO conventions. And it is true that the ILO has said that minimum service levels in strikes is permissible for a state to lay down by way of law, but only on certain conditions. And the conditions are that the minimum service level in any sector has to be negotiated between the so-called social partners, that's to say the trade unions on the one side and the employers in the sector on the other. Secondly, where a strike is declared, it's then a requirement that the union or unions involved and the employer or employers involved negotiate how that minimum service level is to be put into effect in relation to that particular strike. And the third condition is that in the event of a failure to agree on either the first or the second condition, the parties have the ability to go to law or to arbitration in order to resolve that difference. Now, none of those three conditions are met by our Strikes Minimum Service Level legislation. And that means, in my opinion, that the UK is in clear breach of its international legal obligations. Now, international legal obligations can't normally be enforced directly in an English court for constitutional reasons. But nevertheless, it does seem to me that that is a legitimate consideration for councils to bear in mind when weighing up whether or not they will exercise their discretion, for they do have a discretion, whether or not to issue work notices to require people to work during a strike to which the minimum service levels legislation applies. Now, we will know definitively, we don't have to rest simply on my opinion, we will know definitively because the TUC has lodged an application to the ILO, but it may not be dealt with for many months. At the moment, it's clear enough in my view that this is in breach of international law, and councils are entitled to take that into account. I have raised this in the House of Lords with ministers, and the minister's answer is always, well, we believe that we are not in breach of international legal obligations in this respect. But they've never ever given a reason why they are justified in not complying with the three conditions that I've outlined. And that makes me think that underneath it all, they must accept that they are in breach of international law.